Welcome back to Save the Constitution. Produced by Robert Welch University. Today, we will be discussing the Bill of Rights, the first 10 amendments to the United States Constitution. The Bill of Rights is a set of amendments required by various state ratifying conventions before they would ratify the Constitution. The founders wrote a preamble to the Bill of Rights to explain its purpose. It reads in part, "The conventions of a number of the states, having at the time of their adopting the Constitution expressed a desire, in order to prevent misconstruction or abuse of its powers, that further declaratory and restrictive clauses be added, and as extending the ground of public confidence in the government, will best ensure the beneficent ends of its institution." Preamble to the Bill of Rights. In other words, the Bill of Rights was added by the founders to clarify the Constitution's limits on the powers of the federal government. We begin with the First Amendment. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. The Bill of Rights, Amendment 1. The founders believed that conscience is refined by religion. This is why Washington said that religion is an indispensable support to our government, and John Adams said that our Constitution was meant for only a moral and religious people. That is why the founders enthroned freedom of religion in the First Amendment. That is why they made provision to set up schools which taught religion in the Western territories. That is why Jefferson included the fundamental principles of religion in the Declaration of Independence. The founders realized that the absence of religion was a form of societal suicide, wrote Joseph Andrews. Liberty needs morality, and morality needs religion. According to Alexis de Tocqueville, liberty regards religion as its companion in all its battles and its triumphs, as the cradle of its infancy and the divine source of its claims. It considers religion as the safeguard of morality, and morality as the best security of law and the surest pledge of the duration of freedom. But the founders did not want the state-sponsored churches that were common in Europe. For that reason, the Congress is explicitly denied the right to interfere with religion. James Madison explained, "There is not a shadow of right in the general government to intermeddle with religion. Its least interference with it would be a most flagrant usurpation." Why do we see so many restrictions on religious exercise? We know Madison would have called them flagrant usurpations. As we look at various rulings from the Supreme Court, we see rulings that clearly restrict religious exercise. The reading of a non-denominational prayer in a public gathering is seen as unconstitutional, and so is starting the school day with a reading from the Bible. Do these rulings violate the First Amendment? Yes, but there is a remedy. The Congress can limit the appellate jurisdiction of the Supreme Court as outlined in Article 3, Section 2. That would protect our religious freedom and other freedoms from usurpations by the Supreme Court. The First Amendment continues by specifying that Congress cannot make laws abridging the freedom of speech or of the press. The Bill of Rights, Amendment 1. The rights to free speech and a free press are fundamental to other rights. Without the right to free speech and freedom of the press, we lose the right of the people peaceably to assemble and to petition the government for a redress of grievances. The Bill of Rights, Amendment 1. What is the use of assembling or petitioning if we cannot speak freely? How can we know about grievances caused by the government if the government censors the press? Next, we turn our attention to the Second Amendment. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. The Bill of Rights, Amendment 2. Richard Henry Lee, a signer of the Declaration of Independence, argued that to preserve liberty, it is essential that the whole body of the people always possess arms and be taught alike, especially when young, how to use them. James Madison observed that the people's right to bear arms is a defense against governmental ambition. Besides the advantage of being armed, which the Americans possess over the people of almost every other nation, the existence of subordinate governments to which the people are attached and by which the militia officers are appointed, forms a barrier against the enterprises of ambition, more insurmountable than any which a simple government of any form can admit of. In other words, although local and state governments in theory protect individuals' rights against usurpations by the federal government, the most fundamental protection of liberties against governmental encroachments on them is the right of individuals to keep and bear arms. If you're interested in learning more about the push for gun control and the forces behind it, we invite you to read Disarming Americans from Freedom First Society. The Third Amendment sets restrictions on the quartering of soldiers. No soldier shall, in time of peace, be quartered in any house, without the consent of the owner, nor in time of war, but in a manner to be prescribed by law. The Bill of Rights, Amendment 3. Author Joseph Andrews tells us that the quartering of soldiers in civilians' homes in Europe had led to many problems by the 18th century, as we might imagine, and was considered to be worse than the plague. The practice had likewise caused problems in America, and was one of the abuses of power by the king listed in the Declaration of Independence. The Fourth Amendment begins, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated." The Bill of Rights, Amendment 4. Unreasonable searches and seizures means those done without regard to the restrictions that are given in the next part of the amendment. No warrants shall be issued but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. The Bill of Rights, Amendment 4. In other words, warrants must be specific in describing the place to be searched and what is to be seized. King George III had issued warrants called writs of assistance, which were warrants that did not clearly describe the place to be searched or the persons or things to be seized. Obviously, the use of such writs could and did lead to widespread abuse. Now we turn our attention to the Fifth Amendment. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia when in actual service in time of war or public danger. The Bill of Rights, Amendment 5. We learn from Cleon Skousen about grand juries. When it appears that a crime has been committed, either the county sheriff or a U.S. Marshal convenes a grand jury. The grand jury may investigate the matter themselves. If they determine that the person in question could have committed the crime, they issue a presentment. If the grand jury simply listen to evidence presented by the prosecuting attorney and decide they believe that the person in question could have committed the crime, they issue an indictment. The result of either an indictment or a presentment is a trial. The Fifth Amendment adds another layer of protection for individuals accused of a crime. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb. The Bill of Rights, Amendment 5. To be put in jeopardy means to be put on trial. This clause in the Fifth Amendment prevents an individual from being repeatedly charged and tried for the same crime as had been the case in England. The next clause of the Fifth Amendment spells out our constitutionally guaranteed right against self-incrimination. Nor shall any person be compelled in any criminal case to be a witness against himself. The Bill of Rights, Amendment 5. The Legal Information Institute explains, according to this constitutional right, individuals have the privilege against self-incrimination. They can refuse to answer questions, refuse to make potentially incriminating statements, or refuse to testify at a trial in any criminal case. The Fifth Amendment provides additional protections for citizens of the United States. Nor shall any person be deprived of life, liberty, or property without due process of law. Nor shall private property be taken for public use without just compensation. The Bill of Rights, Amendment 5. This clause guarantees to citizens that the government must abide by the law and cannot arbitrarily deprive any person of life, liberty, or property, even when the private property is intended for public use. But what about when an individual is accused of a crime according to due process of law? That individual still has the following rights guaranteed by the Sixth Amendment. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. The Bill of Rights, Amendment 6. Like the Fifth Amendment, the Sixth restrains the federal government from abusing individuals accused of a crime. The Seventh Amendment clarifies what the right to trial by jury means. In suits at common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law. The Bill of Rights, Amendment 7. The Seventh Amendment prevents higher or appellate courts from re-investigating and then making up their own mind about the facts of a given case. If the original trial was valid, the Court of Appeal may not investigate the facts again, but must take them as they were decided. In law, a fact, as defined by the Legal Information Institute, is an event that actually happened, or a statement presented as objective truth. Andrews tells us that this provision protected local juries from possible federal interference. The Eighth Amendment describes limits for bail, fines, and punishments. Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. The Bill of Rights, Amendment 8. This amendment places further restrictions on the relationship between the court and the accused. Cleon Skousen defines excessive bail as a bond which is so high that a prisoner cannot possibly provide it, and thereby regain his freedom pending the date of the trial. Skousen continues, excessive fines are described in the Magna Carta as those penalties which constitute a forfeiture or deprive a man of his ability to earn a living or pursue his calling and business. Regarding the term cruel and unusual punishment, Skousen informs us that under English law such punishments as these were legal: cutting off the ears, flogging, cutting off hands, castrating, slitting of the nose, and branding on the cheek. The Eighth Amendment restrains the courts from inflicting such barbaric punishments. The Ninth Amendment reads as follows: the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. The Bill of Rights, Amendment 9. This amendment is, in effect, a safety net. It is as if those writing the Bill of Rights said, look, we listed certain rights that we thought were of supreme importance. That doesn't mean that the people don't have other rights. The 10th Amendment is a powerful restriction against federal usurpation. The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people. The Bill of Rights, Amendment 10. The 10th Amendment is necessary to prevent a problem that Alexander Hamilton foresaw arising from the addition of a Bill of Rights to our Constitution. He explained the potential usurpation in the Federalist Papers. I go further and affirm that Bills of Rights, in the sense and to the extent in which they are contended for, are not only unnecessary in the proposed Constitution, but would even be dangerous. They would contain various exceptions to powers not granted, and on this very account would afford a colorable pretext to claim more than were granted. For why declare that things shall not be done which there is no power to do? Why, for instance, should it be said that the liberty of the press shall not be restrained, when no power is given by which restrictions may be imposed? I will not contend that such a provision would confer a regulating power, but it is evident that it would furnish, to men disposed to usurp, a plausible pretense for claiming that power. They might urge with a semblance of reason that the Constitution ought not to be charged with the absurdity of providing against the abuse of an authority which was not given, and that the provision against restraining the liberty of the press afforded a clear implication that a power to prescribe proper regulations concerning it was intended to be vested in the national government. This may serve as a specimen of the numerous handles which would be given to the doctrine of constructive powers by the indulgence of an injudicious zeal for bills of rights. The 10th Amendment specifically blocks this doctrine of constructive powers by making it clear that the federal government cannot exercise powers not specifically granted to it. This amendment was intended to prevent the dangers from a Bill of Rights that Hamilton feared. In fact, this amendment recalls the thunder and lightning of Mount Sinai. The federal government shall not appropriate any powers not specifically granted in this Constitution. They belong to the states respectively or to the people. But the Constitution is not self-enforcing. The preservation of our constitutional liberties requires an informed and vigilant populace who will hold elected leaders accountable for their actions with respect to the Constitution. Please share this video with your friends. Each person educated about the Constitution will make a difference. Join us for Part 6, The State Governments. Please visit robertwelchuniversity.org and freedomfirstsociety.org for more educational material.